So, good morning, everyone. Bonjour à toutes et à tous. Welcome to the University of Ottawa, and thank you so much for being here, for bringing law and practice. A warm welcome to everyone joining us online. Nous souhaitons rappeler que cet événement se déroule sur le territoire non cédé et non abandonné de la nation algonquine Anishinaabe, où nous avons le privilège de travailler et d'apprendre. Le travail de cette chaire est guidé par un engagement vers la justice, l'équité et la responsabilité, des principes qui font écho aux appels continus pour le respect des droits autochtones et la prise en compte des héritages persistants de la colonisation. En réfléchissant aux questions de mobilité, de déplacement et de justice, nous nous souvenons des histoires profondément enracinées des peuples autochtones dont les droits, les relations au territoire et les souverainetés doivent être respectés dans les conversations sur l'appartenance, la protection et la gouvernance. Nous nous engageons à mener ce travail avec humilité, intégrité et en reconnaissant les responsabilités qui accompagne la conduite de recherche sur ces terres. So you will have seen our land acknowledgement on screen in both languages. I have just read it in French. A brief word on language for today. So the presentations will be delivered in English, the working language shared by all of today's speakers. We would, however, be very glad to take your questions in either French or English. Please use whichever language you are most comfortable with. It is a privilege to see such a range of people in the room today. We are especially honored to welcome Her Excellency Muhammad Salim from High Commissioner of Pakistan, together with consular representatives from Pakistan and Mexico. A warm welcome to our colleagues from the federal and provincial governments, from legal clinics, law firms, and migrant advocacy and support organizations, and from settlement and worker health organizations. And a warm welcome to our academic colleagues from across the country. So a few quick practical notes. No, that's okay. Yeah, that works. So you have seen the QR codes in the room. This is for the program of the conference, so you can certainly use it. The morning lecture is also being live streamed and recorded. Online participants, please look out for polls. The recording will afterwards be made available in both English and French with subtitles. Photographs and B-roll are being taken throughout, including a group photo at 12:20, sorry. If you would prefer not to appear, please sit in the picture-free area location here, or see our team at the registration desk. During the Q&A period, please wait for a microphone before speaking so our online participants can hear you. And those joining us online are welcome to send their questions through the Q&A box. Lunch will be served at 12:30, just beside in room FSS 1006, so a very short walk from here. So 1 minute on why this research, why we are here. 1 minute. Section 91 of the Immigration and Refugee Protection Act restricts who may lawfully provide immigration advice or representation. For years, this left the NGOs that support migrant workers deeply uncertain about what their frontline staff could and could not do. On October 2024, ministerial clarification confirmed that salaried NGO workers are no longer coped by this restriction, an important step, but as we heard directly from frontline workers and organizations working with frontline workers, real uncertainty remained on the ground. So between June 2025 and this month, our team carried out participatory research with the Newcomer Legal Clinic and a community-based organization that prefers to be anonymous, which led to the toolkit, including interviews with frontline workers, settlement officers, lawyers, and paralegals across Ontario. What they told us was clear. They needed practical, consistent guidance. And that is what the toolkit you will hear about today sets out to provide. So on that note, it is my pleasure to give the floor to Cynthia Quiroga, Director of the Office of Public Policy Research and Outreach, who will say a few words about the Alex Trebek Forum for Dialogue. Cynthia, over to you.
Thank you so much, Professor Nakache. Merci pour l'introduction. Bonjour à toutes et à tous. Que vous soyez ici en personne ou en ligne. Good morning, everyone. It's a pleasure to see you all, dear colleagues, friends, collaborators. It's always a pleasure to be among you. Where is he? My colleague Yves Leboutier was saying that, there. It had been a while since we had run into each other, so I'm really thrilled to be here. I was for a very long time Assistant Dean Research at the Faculty of Law, and I feel I miss you guys whenever I get to be part of one of these activities. C'est vraiment un réel plaisir d'être ici ce matin au nom du cabinet de la vice-rectrice à la recherche et à l'innovation. Cet événement, en fait, il s'inscrit dans le cadre du Forum pour le dialogue Alex Trebek, qui a pour mission de favoriser des conversations comme celle-ci, des conversations qui comptent, des échanges entre chercheurs et chercheuses, praticiens, praticiennes, communautés autour d'enjeux les plus pressants de notre temps. The Alex Trebek Forum for Dialogue is the leading initiative at the Office of the Vice President, Research and Innovation that convenes researchers and representatives from civil organizations, governments, to lead conversations like this one, like the one we will have today. And in a constantly shifting world, it feels like few issues are more pressing than the protection of migrant workers. People who contribute enormously to our economy and to our society, and who too often do so without adequate legal protection, without knowledge of their rights, and without easy access to the organizations that could help them. Et c'est donc précisément là qu'intervient la recherche que vous allez entendre aujourd'hui. La professeure Delphine Nakache, titulaire de la chaire de recherche universitaire sur la protection des migrants et le droit international, et la Dre Jane Ezirigwe, chercheuse postdoctorale, ont mené un travail rigoureux et profondément ancré dans la réalité des organismes qui accompagnent les travailleurs migrants au quotidien. Professor Nakache and Dr. Jane Ezirigwe's work doesn't stop at the academic paper. It goes further and into the hand of frontline workers in the form of a practical toolkit designed to help NGOs navigate complex legal frameworks and identify risks and better serve the people who come to them for help. And at the Office of the Vice President, Research and Innovation, we firmly believe that university research has to be useful and has to lead to this type of real-world impact, not just landing in academic journals. And it's not to, I don't mean to minimize the contribution that science has through peer-reviewed publications, but it also has, it can and should have real-world impact in clinics, in community organizations, and should support the daily decisions of the people doing this difficult but essential work. Et donc, je voulais terminer en disant que ce projet est un excellent exemple de ce à quoi ressemble cette ambition en pratique. Une recherche qui part du terrain, qui retourne et qui laisse entre les mains des praticiens et des praticiennes des outils dont ils ont vraiment besoin. Et je veux remercier Dr Nakache et Jane Ezirigwe. Where are you, Jane? Hello, Jane. Thank you for the contribution that you'll be making today, and to everyone speaking and contributing to today's event to make this possible. And yeah, so again, thank you very much and congratulations for putting this together for today. I look forward to the conversations and to be part of this event until noon-ish. And I wish you a really great day.
Bonjour à tous et à toutes. Je m'appelle Viviana Fernandez. Je suis la directrice associée au Centre de recherche et d'enseignement sur les droits de la personne à l'Université d'Ottawa. Good morning to everyone participating in today's event. It is a pleasure to welcome you here on behalf of the Human Rights Research and Education Center located at the University of Ottawa. My name is Viviana Fernandez and I am Associate Director. For us, it is a real pleasure to be partners in this initiative and to see so many faces with whom we have worked for a few years now. In particular, our esteemed academic member, Delphine Nakache, who has been associated with the center in different capacities for many years. And our former postdoc fellow, Jane Ezirigwe, who joined us in October 2024, and with whom we have been extremely pleased to follow her progress and engage in a few activities and events that she has helped put together, leading to the launch of the chair last year, which was also a great event. Jane is a fellow of our center currently. And it's also a pleasure for us to acknowledge the presence of Christiana Saguet, who is a student member of our center, PhD candidate, and the student representative of our student cohort, which most times is composed of PhD candidates in different faculties at the university. Of course, the topic and its importance is been acknowledged brilliantly by my colleague Cynthia Quiroga, so I will not waste our time on that. And I do look forward to hearing all of the interventions of the different presenters today, as well as encourage people to participate in the debates and discussions and exchanges, just to make this this moment that we're sharing together even more meaningful and productive. On behalf of the center, we look forward to what's to come after the event, which is normally a lot of work as well, and to assist in any initiatives to broaden the reach and bring other people and partners together to make the results even more meaningful and the use of the tool that has been created even more powerful. So I'll cede the floor to our colleague Yves Le Boutelier.
Alors, bonjour à tous et à toutes. Mon nom est en effet Yves Le Boutelier. Pour ceux qui ne me reconnaissent pas de cette photo, là, donc qui date environ la moitié de la pandémie, je dirais. Bon, alors I was asked to say a few words on the link between this event and the mission of the common law section. I know very well both the first strategic plan of the common law section that was developed under the deanship of Adam Dodek, so quite a few years ago, and the second strategic plan developed under the current dean, Kristen Boone. In both cases, I was a vice dean and part of the team that was tasked to come up with a plan, and I can therefore attest that social justice was and still is very much a core element of both of these plans. Et ça, ce n'est pas une surprise. Cela s'inscrit dans la continuité, étant donné l'engagement de longue date qui remonte vraiment des décennies de la section de Common Law envers la justice sociale, l'inclusivité et de même l'enseignement de la Common Law en français et en anglais. Our collective vision as a faculty is straightforward and resolute. It reads as follows. We aim to be a national leader in legal education and research with a commitment to fostering an inclusive community and advancing social justice. We will empower students, faculty, and staff to solve complex challenges, foster innovation, and advance equity through transformative legal education. Parmi l'un de nos nombreux objectifs est le suivant, renforcer l'inclusion, la diversité, l'équité et l'accessibilité. In other words, inclusion, diversity, equity, and accessibility dans l'enseignement du droit, en intégrant des perspectives sous-représentées, des études de cas diversifiées et des pratiques pédagogiques inclusives à l'échelle du programme. Today's seminar on bridging law and practice, supporting migrant workers through NGO capacity building fits admirably well with both the common law section's visions and objectives, bringing together a wide diversity of key actors that provide essential support to migrant workers. And I know that there's a lot of other people attending through Zoom as well. I was pleased this morning as I opened my computer and I had to look at the proposals for research at graduate studies. The first proposal I opened was on migrant farm workers. So there's a new generation already coming up. Ce sera aussi l'occasion d'examiner en profondeur une disposition importante de la loi, l'article 91, une disposition qui mérite davantage notre attention. Et moi, j'enseigne en droit de l'immigration des réfugiés, puis je dois dire que je vais en apprendre beaucoup aujourd'hui parce que typiquement, ce n'est pas une disposition qu'on regarde honnêtement là, dans le cadre des cours. Donc, je vous souhaite donc une excellente journée. Je dis bravo à Delphine Nakache et toute son équipe pour cette initiative. And hopefully we'll have time to meet at lunch. Bye.
So good morning, everyone. Can you hear me? Yes. I need to use the microphone, or can you hear me very well? Great. Okay. You hear me better? Great. Good morning, everyone. Thank you so much for coming. I'll join others to welcome you to this public lecture where I'll be presenting my postdoctoral research titled Bridging Law and Practice, Supporting Migrant Workers Through NGO Capacity Building. And so on this research project, we focused on help, harm, and the hidden rules shaping migrant workers' support. And I'll start by giving a few facts, stating them. Every day, migrant workers seek help. And every day, frontline organizations try to respond. And when I say frontline organizations, I mean NGO workers, settlements organizations that offer several kinds of assistance to the migrant community. And they've built a lot of good and trusting relationship with this migrant community that they become the first point of call where migrants need any kind of assistance, including immigration assistance. But then what happens when someone needs help? Well, the people trying to help are unsure of how best to help. That's a lot to unpack, but I'll do that with a simple example. And so Edward has been receiving several kinds of assistance from Dominica's organization. And then he walks in one day to say, I want to renew my work permit. Could you help me fill out a form? Sadly, Dominica says, not this time. I'm sorry, I don't want to get into trouble. This was a regular occurrence before the 2024 ministerial clarification. And so before this clarification, IRCC had interpreted a worker's salary as a form of consideration. And so paid NGO workers risked violating the law by providing assistance to migrant workers. But then the Canadian Council for Refugees led an advocacy insisting that NGO workers' salary should not be considered as compensation. IRCC finally accepted that and clarified that, moving on, NGO workers can now give immigration advice without breaking the law, as long as there is no direct or indirect payment. And so the research started and we sought to find out, is this clarification enough? And what we found is that, first, there is limited awareness of the clarification itself. The fact that the clarification has been made is there, but a lot of frontline workers did not know about it. And when I say frontline workers, again, I'm talking about NGO workers and settlement agencies, and I'll be using these words interchangeably. And so some NGO workers were not aware that this clarification was existing. And even for those that were aware of that, they could not understand the implications on the work they do, because nothing has changed significantly since the clarification. It reduced some fear among some people, but it did not resolve the practice level confusion, especially the confusion around key terms like what is immigration advice as used in the clarification, and words like indirect payment. What do they actually mean? We also sought to find out the perceptions and reactions of the stakeholders to Section 91. And we saw that the lawyers and paralegals were more in tune with what the section was trying to do, restrain and restrict the kind of advice that could be provided under Section 91, arguing that there was risk that incorrect help, even though it could be well-meaning, or untrained advice could lead to, right? This way? Okay.
They don't see her online.
Okay, okay, thank you. Okay, perfect. I hope you can see me now. Yeah, so yes, the lawyers insisted that there should be some kind of constraints as to the kind of help that could be provided under Section 91, especially given the fact that sometimes well-meaning advice could result to irreversible damage for the migrant workers. And they cited a few cases where they've had to inherit files that were badly handled in the past, and they had to correct the work, and sometimes it becomes impossible to even correct some of this work. But then there was an interesting finding with one of the lawyers insisting that it wasn't just the NGO workers that could be guilty of incorrect work or untrained advice. That in fact, in her practice, and I quote, I have never had to correct work done by NGOs, unlike work from immigration consultants. Now, for the NGO workers themselves, they interact with Section 91 with a lot of emotional burden, fear, uncertainties, and sometimes this leads to delays, denials, and refusal to offer assistance to migrant workers who need it, who eventually go without this assistance being offered to them, or time has lapsed for it to be offered to them. But there was also an interesting finding that apart from the limits within the Section 91, frontline workers were also struggling with funding limitations and liability and competency concerns. And so under some funding arrangements, some funders insist that some categories of migrant workers cannot receive assistance. So for example, we see people like refugee claimants or those that are out of status. The funding agreement will not let them offer assistance to this set of migrant workers. Again, and very, very importantly, we also saw that the frontline workers were also concerned about their own competencies to offer some of these advice and assistance. And I will quote a frontline worker who is a paralegal, but the person says, "I certainly don't believe that I have the competence to advise somebody about immigration law or to do immigration work." Now, like I said, there was still confusion around what is immigration advice, what is indirect payment. So we're interested in knowing how stakeholders interpreted that. And for the NGO workers, they see immigration advice as a practical process-based assistance to migrant workers. And they distinguish it from legal advice, which they believe is where you apply authoritative judgment or recommendations to a specific case. Now, the lawyers warn, and rightly so, that sometimes what seems like a mere administrative task will quickly turn into a complex legal issue. And in the case of Edward asking Dominica for merely filling out his forms, you could find out that within those interactions, it could be that he has a criminal record or inadmissibility concerns that quickly turn that mere administrative task to a complex legal issue. Now, interestingly, I want us to understand the space that migrant workers and frontline workers play in. It's a space where there is a lot of relationship building and gift giving. Now, in this space, we begin to battle with how do we interpret gifts? Because the IRCC says indirect payment, including gifts, could be considered as consideration. And so in that space where there have always been some kind of gift giving and trust building, what should be seen as gift? For example, if Edward offers Dominica a bunch of flowers from his garden, would that from his farm, would that be considered indirect payment? If he's coming back from his home country and then brings a cultural item and offers it to Dominica after some service, would that be considered as indirect payment? Again, we begin to ask questions like, is it the volume of the gift or the time frame between when the service was provided and when the gift was offered? Or is it where it is a personal gift as against an organizational gift? Is that where we begin to draw the line between indirect payments and gifting? And while we all agree that giving a truck of apple to someone is inappropriate, what happens if it's a basket of apples to the whole office? What happens if it's just cookies being offered? But what we found, interestingly, is that after the 2024 clarification, a lot of organizations tightened their gift policies, with a lot of them banning even cookies and saying we don't take any kind of gifts. We're also interested in finding out what triage and referral gaps exist, because we were thinking about partnership building. And we saw that there were no triage or referral tools in existence, or they were very informally used or inconsistently used. So a lot of frontline workers rely on personal networks, on patchwork of informal practices or organizational culture to triage and refer cases. Now, this is actually less problematic with organizations that have in-house legal expertise, or those that have a nearby legal clinic or have a close relationship with a legal clinic. But the good news is there are some partnerships that are working. We see one in the Niagara region between a legal clinic and a settlement agency. We see another good example in Thunder Bay, where a legal clinic and a settlement agency are working really closely and well. Yes, they are in the room here, and I can see them. Yeah, and the truth is that there are a few public resources, and we're not saying there is nothing there. For example, the IRCC has a lot of materials online on procedures and all of that. CLIO has its guided pathway to open work permit application. There is the Barbara Schleifer's Clinic's toolkit on H&C. But then there are no tools to help triage or guide referring workers to more regulated help. And we believe that partnership is very important in this space because we've already identified that there are funding gaps where some certain categories of workers cannot be attended to under some funding arrangement. And so where we have a good partnership, some of those categories of workers could be moved around the system to be accommodated by those that have more liberal funding. Again, in structuring this partnership, we are thinking that there will be need to balance confidentiality with the need for feedback to the frontline workers. And that is because some of the frontline workers were complaining that sometimes when they refer cases to lawyers and try to follow up, the lawyers shut them out and don't give them any feedback. But the lawyers argue that, well, there is a confidentiality expectation and obligation between the client and the lawyer. In building this partnership, we think that it's important to incorporate the LSO's free services, pro bono services by law firms, legal aid, and even advocate for paid services, referring them to paid services because not all migrant workers cannot pay for themselves. But in practice, we see that a lot of the frontline organizations do not refer to paid services. They would prefer to refer to free services. Now, what did the practitioners ask from us? They were unanimous in demanding that we should give them a practical toolkit, emphasizing that it should be accessible, it should balance the clarity and complexity inherent in immigration, in the immigration system. And trust me, it's really huge there. And then it should be adaptable across contexts. Again, we saw people working in remote and rural communities asking that we don't do a one-size-fits-all kind of output, but we should think about people working in remote and rural areas where the urban infrastructure and certain things that work in the urban setting would not be applicable. But then, interestingly, again, we see a binary view. The lawyers and the paralegals feel that we should focus more and that the goal of the toolkit should be to have clear stopping points, reinforced red flag discipline. They call it red flag indicators. And then there should be structured escalation rules to help frontline workers, manage what they can take. But the NGO workers, we are more interested in things that will give them clarity on permissible assistance, to be able to act with confidence and permission to act early enough, and again, consistently, without fear, while still clarifying when referrals or consultations was necessary. Another unanimous ask was that checklists alone wasn't going to be enough in this case. And so there were a lot of demands, and then we went into work. I want to say a word about the methodology of this research. It consisted of researchers from the University of Ottawa, the Newcomer Legal Clinic, and a community-based organization that prefers to stay anonymous. We interviewed 12 NGO workers, settlement officers, lawyers, and paralegals in Ontario, coming from the Niagara region, Windsor, Simcoe, Ottawa, Thunder Bay, Sudbury, and Toronto. We also have 5 external experts reviewing the toolkit. For our dissemination strategy, we have this public lecture, which is ongoing, and we have a policy roundtable in the afternoon. We intend to have the toolkit in multiple formats, PDF, online version, mobile friendly, and also have some short videos. We intend that it will be in multiple languages, and later on have some simpler, more concise formats. I'll quickly take you through the toolkit development process. First, we were guided by insights from the in-depth interviews. Then we identified needs and priorities, reviewed the IRCC guidance documents, policy materials, and adopted the CCR's framework on quality service. We developed the toolkits, incorporated feedback from collaborators. It went through multiple revisions before we sent them to the 5 external reviewers who are currently reviewing it. We intend to refine it for accessibility, practical relevance, legal accuracy, and sustainability for use. We also intend to draft some templates for documentation and then pilot test it with a partner organization. This is a quick overview of what the toolkit consists of. It's titled A Toolkit for NGO Workers, Supporting Migrant Workers Within the Limits of IRPA Section 91. It has 11 components. 8 have been fully developed and 3 still need to be developed. The first we have there is key terms explained, and a lot of the speakers coming after me would explain these in more details, but the key term explained is like a glossary that explains the foundational definitions and legal concepts. We have a few tools that help with assessment. There we have the organizational readiness and compliance checklist, the frontline workers compliance checklist, and the legal and immigration needs assessment tool. For decision-making and referrals, we have the quick reference, we have the companion decision tree, and the red flag list. For building partnership and connections, we have the important connections, and then we have the key resources. To make it more adaptable and apply it to real-life cases, we have the case scenarios, and then working in rural and remote contexts. For sustainability and support, we acknowledge that there will be need for training programs for the toolkit users. We also acknowledge that there will be some kind of consultation by us to reach out to people to form the partnership networks that would help with the implementation. We also believe that there should be regular updates as policy and practice evolve. And there should also be advocacy for complementary policy reforms. Now, let's return back to the story that we started with. Here, we believe that if Dominica is given this toolkit, then she will be able to help Edward fill a simple work renewal form and submit it on his behalf. And if Jose walks up to Dominica for this kind of assistance, but during interactions, she discovers that he has a criminal record, for example, then she would be able to effectively refer to regulated professional legal helpers. And we believe that if Tina is coming back from her country and brings a cultural item, depending on the organization's policy, Tina will be able to know whether to accept that or not. A few conclusions can be drawn. We strongly believe that clear guidance and support will empower frontline workers to provide timely and safe help. And we believe that this will positively and significantly affect the justice system because there will be less demand on regulated advisors to focus on giving professional legal help to those that really need it. And that will make more people have access to justice. We also believe that the system challenge is beyond the law. So it's not just about the law. We believe that there should be guidance on clarity, there should be capacity building around competencies, and there should be coordination around what partnerships and connections are built. I would like to quickly acknowledge a few people that made this fellowship work for me. The chair on migrant protection and international law provided the supervision and partly funded the fellowship. The Human Rights Research and Education Center, as Viviana said, partly funded the fellowship. And the Nigerian Institute of Advanced Legal Studies is my home institution that released me to do this fellowship. I'll be happy to take questions during the question and answer session, and I thank you all for listening.
All right, so oh, good. Okay, so thank you, Jane. And I think I will be presenting probably the most boring part, so I'm very sorry about that. But this is also one of the most important in the toolkit, if I may say, which is really the legal terms, so the terminology. It is very difficult to explain in a short period of time because, you know, the details, in fact, matter a lot. So I will try to make it as clear as possible. And of course, questions are most welcome. And even the way we've designed the glossary, you know, it's also something that we are currently thinking about? Is it the right way of presenting the term? So one word of context first. As I said, the toolkit is really still a working resource. It has not been yet publicly circulated, and what you will hear this morning is really the first public presentation of its content. It has been shared, as Jane said, with our expert reviewers a very short time ago. So, we really would like to thank the reviewers here to share their broad comments, and feedback on the toolkit. We are not expecting, of course, any detailed comments here, but we are very happy to have some guidance from you, Janet, Constance, and David, and others as well who could not be here today. We will hear from you later this morning, and your review is still underway. And your comments really will be the first feedback, like the first feedback we receive on it. So I'm really introducing the toolkit, keeping in mind that for everyone in the room, this is the first time that its content is being presented. So let me start maybe where the toolkit starts, with the situation. A frontline worker sits down with a migrant worker who needs to renew a work permit. The worker has clear current status, no prior immigration history. The request is straightforward, and the frontline worker could help. Yet one question already sits underneath that simple moment: am I legally allowed to do this? Now change a single detail. Partway through, the worker mentions that a previous application was refused, or that last time an employer filled in the forms for them. Is it still a renewal that the frontline worker can help with? Or has it quietly crossed into something that must be referred? And if so, when exactly did it cross? So these questions have all a precise legal source: Section 91 of the Immigration and Refugee Protection Act, IRPA. Section 91 sets a general rule: no one may provide immigration advice or representation for consideration unless they fall within a defined category, i.e. lawyer, paralegal, regulated immigration consultant, Quebec notary in Quebec. For years, Immigration, Refugee and Citizenship Canada treated salaried NGO staff as cooked by that rule, on the basis that a salary was an indirect form of compensation. But then, in October 2024, this ministerial clarification changed the picture. A salary paid to NGO workers would no longer be treated as consideration under Section 91. That clarification was widely welcomed, but our research found it resolved less than it appeared to. Confusion persists about which activities are permissible, and many frontline workers reported little practical change on the ground. So it is precisely that gap between clarification on paper and clarity in everyday practice that the toolkit really sets out to address. And it does from a particular stance, worth naming at the outset. The toolkit treats Section 91 as a form of protection for migrant workers seeking reliable support, for frontline workers navigating high-pressure situations, and for organizations committed to lawful practice. It frames compliance not as a constraint, but as the foundation for safe, effective, and rights-respecting support. So I will cover three pieces of the toolkit. The first is the glossary, the vocabulary used in the toolkit, and the foundation everything else really rests on. The second is what we call in the section of the toolkit the organizational readiness and compliance checklist. What allows, if you want, an organization to put that vocabulary to use safely. And the third is working in rural and remote contexts, not a prerequisite to the other two, but the setting where those foundations face their hardest test. Most of my time today will be on the glossary. So before going to the heart of the matter, a word on a term I have already used, Jane has already used, migrant worker. The toolkit uses it deliberately broadly. It is not limited to people holding a formal work permit. Following the 1990 International Convention on the Protections of the Rights of all Migrant Workers and members of their families, the toolkit extends the term to, and I quote, any person engaged in or seeking remunerated activity in a country on which they are not nationals, regardless of immigration status. So, this is, are we using that term? This is what the international, because that was not what I was supposed to say. I see two same paragraphs. So let's come back. The convention has a very broad definition of migrant workers: seeking work or working with or without status. So far, the understanding we have is any temporary migrant working in Canada with or without a valid work authorization. So it's not quite the same, but this is how we understand migrant workers. So all this to say that we have a broader definition than, you know, the term migrant worker itself. And why? Because again, you know, given all the transitions of status currently in Canada, and given the fact that on the field, NGOs are not always serving only migrant workers, we wanted to have a more inclusive term. So that definition of the migrant worker is where the glossary begins. It sits in part 1, the preliminary notes, which really tries to situate migrant workers' live realities and legal position so that the definitions are not read in abstraction. From there, the glossary moves to part 2, the core concepts, and that is where I will spend most of my time with you. The legal threshold of section 91, the boring part, okay? Part 2, 3, then part 3 of the glossary turns to the threshold into practice, how to work responsibly within the limits, and I will give you only its organizing ID at the end, rather than going through each term, which would be really, really cumbersome. So, what is regulated under Section 91 and what is not? The answer turns on a single key term, one that was mentioned a moment ago, consideration. Okay. In the Section 91 sense, consideration means a benefit that flows from the client or from someone acting on the client's behalf to the person providing immigration assistance. It is, in the toolkit's words, the legal trigger, what brings an act of advice or representation within the scope of Section 91. The corollary matters just as much. Where there is no consideration, the Section 91 prohibition is simply not engaged. So this is where the October 2024 clarification comes in. Since October 2024, IRCC has confirmed that a salary paid by an NGO to its own staff is not consideration from the client, even though the staff member is, of course, paid for their work. Volunteers, I want to be very clear, were never within Section 91 to begin with. I want to be precise here because this is exactly where summaries go wrong. The clarification did not abolish consideration. An NGO salary is not consideration from the client, but fees paid by the worker, payment by an employer on the worker's behalf, funding tied to processing that worker's files all still count. And where consideration is present, the prohibition is engaged. Consideration tells us when Section 91 applies. The next question is what Section 91 actually regulates. And that turns on 4 easily confused terms: legal information, legal advice, immigration legal advice. Okay? A point to flag. The toolkit looks at this in the Section 91 sense specifically, not in the broader sense of legal practice. So legal information, what does that mean? This is explaining how a process works, what options generally exist, or what rights a person holds, without, and that's important, applying any of that to the individual's own situation. Telling a worker how permit renewals work? Or which documents IRCC usually requires? It's legal information. Section 91 does not regulate it. Anyone may provide it, paid or volunteer, trained in immigration or not. Legal advice that is applying immigration law to one person's specific circumstances, exercising judgment about how the law interacts with the person's specific facts. The toolkit points the pivot point precisely, and this is one phrase that is worth quoting. The moment an NGO worker moves from general explanation to advising a worker on what their specific situation means, what they should do, or how a rule applies to their history, they have moved from information into advice. And this is the kind of activity that Section 91 regulates. It prohibits legal advice on immigration matters for consideration by anyone outside the regulated categories. Immigration advice in IRCC's own terms, so the Immigration and Refugee Citizenships Canada owns term, from its May 2025 questions and answers, it is not a different activity from legal advice on immigration matters. It is the same activity named by IRCC. What makes it matter is the previous clarification from IRCC. A salary paid by an NGO to its staff is not consideration from the client. So where there is no client payment, Section 91 is not engaged, and immigration advice is permissible for salaried NGO staff. IRCC will therefore is expected to accept applications on which they have provided it. And then we have immigration legal advice. We discussed a lot, within the team, which is different in nature. And this is a term that the toolkit itself creates for its own practical purposes. You will not find it in Section 91 or in IRCC's materials. It is not about who pays. It is about whether the question demands professional legal expertise, meaning legal judgment, interpretation, strategic assessment, or representation. That is what immigration legal advice is. Immigration guidance calling for one of more of those things. And that work must be referred out to a licensed immigration consultant or a lawyer. So the two distinctions sit on different axes. See why it's not easy to explain. Section 91, since October 2024, turns on payment. Salaried NGO staffs are clear of it. But the line between immigration advice and immigration legal advice turns on something else, whether the questions demands professional legal expertise. So how do you recognize that line in practice? The toolkit points at least to two triggers. The first, where the immigration issue itself carries complex legal consequences. The second, where it intersects significantly with other areas of law, employment, human rights, family, criminal, etc. When either is present, the case would call for professional legal expertise and should be referred. One clarification on that second trigger, where an immigration problem overlaps with, say, an employment problem. Immigration legal advice covers only the immigration analysis itself. The employment question is a separate matter outside of Section 91 altogether. So to hold the line cleanly, and this is how we see things, but we are recognizing that this is open to discussion. Immigration advice, permissible for salaried NGO staff, would take no payment from the claimant. Immigration legal advice, refer. So, of course, that clean, two-way split, immigration advice on one side, immigration legal advice on the other, is how the terms work on paper. In practice, it is less TD, very less TD, and the toolkit is very honest about that. The line between the two is not drawn in advance. A matter can begin as ordinary immigration advice and become immigration legal advice at the moment a new fact surfaces. So the toolkit asks frontline workers to stay alert to those shifts, to recognize the point at which assistance crosses into immigration legal advice and referral becomes necessary. And the toolkit does not pretend to remove the difficulty. It has a section called plainly what this toolkit does not resolve. And it puts the limit directly. This toolkit cannot eliminate the gray zone entirely. Immigration law is complex, fact-specific, and constantly evolving. Even regulated immigration advisors and representatives sometimes disagree on strategy. What the toolkit offers is narrower and more useful, we think. Not the answer to every case. A toolkit cannot do that, but clearer guidance, we hope, on when a case must be referred through the red flag list, the case scenarios, and the decision trees that Jennifer will address earlier on for the red flag list. One more point the toolkit insists on. Even where the Section 91 prohibition no longer applies, a worker is not therefore free to do anything. Three things still shape what they can responsibly do. The conditions in their funding agreements, which can be stricter than Section 91 itself. The organization's scopes of services, of course, this is important, and their competence in the matter at hand. Staying within Section 3 is necessary, but on its own, it is not enough. And that brings me to the other term, the one that our research flagged as the last intuitive of all and the most legally risky, indirect payment. So Jane talked about that already, but I just wanted maybe to come back with some examples that we hope to provide in the toolkit. So far, everything has turned on a simple case. The client does not pay, so Section 91 is not engaged. But what if someone else does? That is what indirect payment is about, money that reaches that NGO from a third party. The toolkit settled this with a single test, and this one is worth keeping exact. Is there a link to the specific client and the specific service? If the benefit can be traced to a particular client's particular file, it is indirect payment, and indirect payment is consideration. Let me apply the test to three concrete cases. Case one, recruitment agency funds the NGO in exchange for processing the applications of the worker it placed. Consideration? Yes. The money is tied to identifiable workers and identifiable files. The link is explicit. We argue. Case two, an employer signs a service contract paying the NGO to handle permit renewals for a named group of its workers. Consideration? Yes. Same reason, the payment is connected to specific clients and a specific service. Case three, private foundation gives the NGO a general operating grant with no relationship to any individual client. Consideration? No. There is no link to a particular client or file, even if the NGO uses that money to do immigration work. So the rules appears as simple. It is never the size of the benefits that matter. It is whether the benefit can be traced to a particular client's particular file. But two things to leave you with. First, this is at least how IRCC seems to have interpreted that. And the second, the risk does not depend on intent. The toolkit is blunt about this. Under a heading that we called Why Good Faith is Not Enough, an arrangement can be entirely well meant, but still count as consideration. Okay? So here is why that matters, because once an arrangement is consideration, the Section 91 prohibition is engaged again. And so, of course, it does no longer protect the work, and the NGO is back to the ordinary rule, etc., etc. So where there is any doubt about a funding or payment arrangement, the toolkit's guidance is simple: check it, even with legal counsel, before the immigration work begins. All right, so I will be very brief on that. The second part of the glossary gathers the terms that governs how the work is done. So we have terms like client empowerment, conflict of interest, protective documentation, red flags, referrals, scopes of services, and others. I won't define each. Bianca and Jennifer take the operational tools next. But I want to give you the organizing idea. Those terms in the two kill words translate legal permission into professional discipline and ethical obligation. And that points to the conceptual hinge of the whole toolkit. Since October 2024, scope of services has become more important, not less. Before that date, Section 91 set an external legal limit on much of this work. After the clarification for salaried staff who take no client payment, that external limit largely falls away. And when the legal limit recedes, the professional one has to take its place. The question is no longer only, is this allowed, but is this within what we are equipped and mandated to do? So two things to carry out of this part. First, client empowerment. The toolkit gives it a striking description. The purpose the entire toolkit exists to serve. The whole document, in the end, is in service of one thing: the migrant worker understanding their own option and making their own decision. And second, the discipline the toolkit repeats throughout. When in doubt, the default is referral. Pause, consult, refer. The second piece of the toolkit is the organizational readiness and compliance checklist. Its purpose is to help an organization put in place the systems and safeguards needed for safe, ethical, and legally compliant assistance under Section 91. The point I want to make today is structural. The glossary then, if you want, tells an individual worker what the terms means. The readiness checklist asks a different question. Has the organization, your organization, built the systems that let you act on it? It runs through several components, from organizational culture and internal triage through to continuous learning and improvement. And this follows directly from what I said about scope. Again, it's no longer is this within your scope, is it within the scope of my organization as well? So someone has to define the organization scopes in the first place. Someone has to build the referral pathways the workers turn to. Someone has to provide the supervision. That is organizational work. And so the glossary tries to equip the individual worker with that kind of tools as well. And then we also have a part on working in rural and remote contexts. Rural and remote communities are marked by low population density, geographic isolation, limited access to services, including legal assistance. Workers there face greater isolation, fewer supports, transportation and connectivity barriers, and heightened dependence on employers for housing and information. The toolkit's framing here is important, and I will quote it precisely. These conditions do not reduce the NGO workers' obligation under Section 91 of ERPA, but they do require adapted, suitable practice. The legal threshold do not bend because a lawyer is 300 kilometers away. What changes is the practice. And referral, in particular, carries more weight here, no less, precisely because referral resources are scarcer. The section is concrete. To take one example, it warns that employer-provided Wi-Fi, phones, and device may be monitored, so workers should always confirm they are on their own private device and connection before any sensitive conversation. So 3 foundations, the glossary draws the legal boundary and the line between what a worker may do and what must be referred. Organizational readiness that builds the systems that make compliance practice possible, and the rural and remote section that reminds us that the obligations hold everywhere, even where the resources do not. The honest message is the toolkit's own. It does not and will not remove the gray zone. What it does give, we hope, is frontline workers a precise vocabulary and a clear default: when in doubt, refer. So thank you. And I will hand it to Bianca.
Good morning, everyone. I guess I can change this. My name is Bianca. I am the now clinic coordinator of the Newcomer Legal Clinic in Thunder Bay. Where's the camera? Like, where should I be standing? Will they see me if I come to the board? Okay, because I'm going to draw on the board. So my section, this board, okay, that's fine, is about how I can, oh, I see the camera. Oh, okay, perfect. Move it up. Yeah, yep, that works. All right, is to kind of explain how the toolkit can be integrated into practice, right? I've been at the clinic for 3 years, but my first 2 years working there, I was hired through the Migrant Worker Support Program, and that was specific for closed work permit holders. That is specific to closed work permit holders, and geared a lot towards seasonal agricultural workers. If anyone here knows Thunder Bay, and I'll talk about it in a second, we don't have a lot of farms up there with temporary workers, so we have to kind of improvise a little bit of how we support closed work permit holders in our area. But really quick, about the Migrant Worker Support Program, part of what I have to do is help these workers apply for open work permit for vulnerable workers application if there is abuse found in their employment situation. I'm going to show you the process of me doing that. So first, I am there from the beginning. I do the initial intake. During the intake, oh, am I not in the, nope, I'm on the wrong board. Sorry, that's my bad. So intake first, then I have to assess for abuse. I ask them a bunch of questions, try not to re-trigger people, and I figure out whether or not they follow and fit into the eligibility criteria of the open work permit for vulnerable workers. I'm going to circle that. Next, because I work at a legal clinic, we do have an immigration lawyer. The immigration lawyer has to review what I assessed and what I decided. After that, if it is found that they truly are experiencing abuse under those eligibility criteria, I have to prepare everything. I prepare the documents, supporting documents. I prepare the application. I help them prepare their statutory declaration or their story, basically, that they have to do an oath for. And I even prepare the support letter that the clinic is supposed to be providing in their application that they were receiving support from legal services. After I do all of that, I have to send it to the lawyer again, who will review everything and administer the oath, because I do not have authority to do that. The lawyer does. They administer the oath of their statutory declaration, and then I am also tasked to prepare for submission. Oh, and between all of that is review and update the application constantly because it's never perfect the first time. These two parts that I circled are the parts that I think that are truly aligned with what the frontline workers that were interviewed fear or have talked about. You need experience to be able to understand if it's abuse. And you have to talk to the lawyer about everything that you're doing. So as I said earlier, Thunder Bay is really far away from here and really separated from a lot of places in the north. But we're not rural. So in our context, we are an urban population, but we serve the rural and remote communities in the northwestern Ontario. We are remote though, because we are so separated from each other. Still, we are a hub, and we have to take into consideration the differences of each community that we're serving. Each community is unique. We may be a hub, but we're the only immigration legal clinic and only immigration legal support in all of Northwestern Ontario, and I can dare say all of Northern Ontario as well. We serve places like Kenora. They have unique needs. You know, there might be, oh wait, I should probably move the camera down. They have a jail there. So there's a lot of crim law and immigration law that we get questions about. Then if you go to Fort Frances, they're right by the border. We get questions about US law, crossing the border, and immigration law. We also are trying to collaborate with Sault Ste. Marie and Sudbury areas. They have people who are community workers like myself, but they don't have a lawyer who's right there available, literally the office next to me, to be able to ask questions when we have doubt, right? Or when they have doubt. But they also really know their areas. They know what they need. So we have to communicate with them and allow them to lead us, because even though we're there training or to support, we don't actually live there. We don't know how the communities are there. They are the experts in their area. And we can't assume their needs. Like we said earlier, we're the only immigration support in Northwestern Ontario. So yes, there's not very many options, especially for low income, no income, and even middle income people who need these services. And I will even say high income. We have a referral list. There's 3 immigration consultants on it. There used to be another immigration lawyer who recently told us they're retiring. So those are all the ones in Thunder Bay area. Everyone else on that referral list is from Toronto or the GTA and Ottawa. So we are constantly having to work together in all of our fields to be able to fill the gaps, to be able to provide these services to people who don't have them. Is this working? There we go. So I'm going to talk a little bit about the organization compliance checklist that is in the toolkit. It is something that when I looked at it, it can very easily be incorporated into organization policies and procedures. There are policies and procedures that are already doing these things. You just got to add a little bit about IRPA Section 91 and you're good. You have the compliance sheet already. It's already available. At my role, it's part of our clinic culture as well. From what I was reading and what I looked through, we already do triage. We already have a referral process. And I'm sure all organizations or organization representatives here, you have a referral process. You know who to talk to. You know who to send people to. And something that we practice in our office is debriefs. So part of this process of communicating with the lawyer, I am constantly debriefing with the lawyer. I'm always asking questions, and I know that's a privilege that I have working in such a close vicinity with a legal representative. But it takes time. There's that fear, or I guess hesitancy, to provide advice or support to someone if you don't really know. But that's the point, is if you're not applying it, you're never going to really learn it. So if you're applying it, then you can practice. Like, I've had 2 years experience. I didn't even know what an open work permit for vulnerable workers was 3 years ago. I also am not from here. So even the whole Canadian immigration system, I had to learn pretty quickly once I joined the clinic. But as you do it, it comes to you. And it doesn't mean that asking for help means you're incompetent if you've been doing it for years. The immigration system itself is constantly changing. I talk about it with our lawyer in the office all the time. He's like, it's so different than it was 3 years ago. I have to look up stuff constantly, and it's going to keep happening. It's something that we all deal with. And we're all part of that system, right? We're all trying to navigate the same system. I just really want to emphasize, oh, sorry. Did I go too far? Oh, I did. This part that's covered by the Zoom thing says escalation is competence, not failure. Like I just said, it is just like when you're a student, asking questions is what helps you learn. It helps you grow, helps you become an expert in your field. That is necessary even when you're practicing. You don't know everything. We're not going to know everything. Lawyers don't know everything either. We talk to each other all the time. We feed off each other. I have that opportunity and I'm grateful for it. But I'm still learning. I'm not a complete expert in what I'm doing. So as far as the workers' compliance checklist, I realized it was a great reminder of what not the red flags per se, but what I can and cannot do. It doesn't cover everything. It's not supposed to. Every individual is an individual. They have their unique circumstances. They might seem, oh, I've done this before, and then you find out later that it's completely different than what you thought it was. That's normal. That happens with every single case. Go with it. If you need help, go ask. If you think you know, still ask and confirm, because asking will also make it'll kind of like re-solidify the knowledge that you have. When I integrated this into my closing files, it took me 6 minutes. It wasn't very long. It's something that I have to do. I don't know if every organization who works with clients has a case management style, a way of like going through their client files, but we do in our office. And every time I have to do closing files, it's a process. It takes time. I actually liked that checklist because, again, it was a reminder of what I should or shouldn't be doing, or couldn't be doing with each person that I'm meeting. So just to end, we're all part of this system and we all interact with it, and we all have our different skills and capacities for it. Lawyers have the legal expertise. We need you. We will go to you. But we also have those who are face-to-face with the clients before they even get to that point. We also need assistance, right? We also have our skills in knowing the individual people before they get to that point. Having a lawyer right next door helps, but that's not reality for everybody. I'm very aware of that. So there's some ideas that we've kind of worked with in our clinic. Lately, we've started something we call it the TVMA Q&A with the lawyer. Once a month, we give an opportunity to the settlement agency that we work with to, it's all morning. They can sign up, each settlement worker specifically, to talk to our lawyer face-to-face or on Zoom or phone, whatever is more easily accessible for them at the time, and ask general questions about immigration related to the files, but not about their files. And then he flags if it needs to be referred immediately or quickly or eventually. But we keep it general so that we can avoid the whole needing to retain someone and whatnot. But we've heard really great feedback. I mean, we have someone here who's experienced it, but we've gotten really good feedback that they like having even just that one 30-minute, 45-minute chat with the lawyer to ask questions so they can feel more competent in the decisions they're making and what advice that they're providing to their clients. Another idea well, not idea, but something that we have been able to do, and which kind of was the start of this research project, was going around and teaching, training settlement workers and community workers about permanent residency pathways. Just clear language. You know, you go through the websites and they're so confusing to everybody. We get it. So we teach the settlement aid workers how to navigate it, how to figure these things out, how to provide the options generally to people so that they themselves are gaining that knowledge and experience to help their clients. And then something else that has come to mind, not something that we're practicing right now, mostly because of funding, but is because we're all part of the system, we're all working together, why not have professional development support for the community workers already in the field? You know, instead of trying, just like each community, they have their needs, right? There are people who are in these organizations that would be great at becoming an immigration consultant or getting certified in that so that they can be a support for that community. So they can bring that knowledge and be able to share it and support the people around them. That's just something that I've kind of thought of recently, but just to end that, again, we're all working together, and I am really grateful for this opportunity actually to be up here. So thank you.
See the camera. Hi, everybody. I'm just going to do a quick check on time. Do you want me to go a little bit faster? Yeah. 10. Yeah. Thank you. No, I'll try not to talk too much. Huge thanks to the organizers, Delphine and Jane, for the amazing research, from Renata for all of the incredible, where did Renata? All of the incredible work, and everybody else on the team, and Bianca, who has worked so hard on preparing for today and who it was really wonderful to hear from. So thank you, and thank you for having us from Thunder Bay. I've been asked to talk about the risks and red flags part of the toolkit, which I guess is maybe because I'm a lawyer and maybe we associate lawyers with loving to tell people about all the risks and all the things they shouldn't do and all the problems we can avoid. And I'm happy to do that. I can do that. But I guess I just want to start out by saying that I have some reservation about focusing too much on red flags and risks. I think it's necessary. We heard from the people who participated in the research that they want to hear about this. But I would also like to remind everybody that risk is not a 4-letter word, even though it kind of is. It's not a bad word. It's not a bad 4-letter word. We live with risk every day. The other piece of risk that I think we need to talk about, and about red flags, is our clients aren't red flags. Like, we need to remember that these are, you know, we sort of think about law school exams. If you've ever done a law school exam, you're looking for issues, you're looking for the problems to spot. Well, our clients are not problems, our clients are not red flags. And I worry sometimes that if we look too much at the red flags and the issues, then we can stop seeing the client behind that. And I don't want that to be what we do. The other piece of risk and red flags that I would like us to think about is that, as Billy Joel said, we did not start the fire. These are not risks caused by clients, maybe some of them clients make some mistakes, but These are not risks caused by clients. These are not risks caused by NGO workers and the decisions that they're making. These are risks that are caused by IRCC and its policies. And the way that the law is changing and the way that the law is developing right now, and the systems that have been put in place to manage immigration, to reduce immigration, to control workflows. Just to give you a sense of why I think it's challenging for NGO workers to take up the call to step in to help people with their immigration applications, is that the world of doing immigration applications has become so much more complicated than it used to be, and so much more complicated than it seems to me that it needs to be. When we help somebody with an immigration application, we're not just filling out a form anymore. We are filling out a form that you then have to validate and upload to a portal. That doesn't sound that hard, right? But there are so many portals now that it's often impossible to know if you're in the right one. And clicking the wrong link on the little algorithm that takes you to the portal that you need to get to on IRCC's site can lead you into making the wrong application. And it's a frustration for the workers, the frontline workers who we speak with and work with, that causes them to say, oh my gosh, well, I need to refer this to a lawyer. I need to find a lawyer who can do this. I need an immigration consultant who can do this. And I don't think that that's how a public system should operate. And so when we talk about red flags and we talk about risk, I just like to keep that in mind, that these are sort of structural issues that have been caused by the system itself. At the same time, it's handy when you're doing this work to have a list of those things that are sort of immediate flags for, oh, this could be a hornet's nest that I don't want to walk into myself and that I need support for, while at the same time doing the work that the frontline workers and NGO workers are so good at doing, which is being the accompaniment to the person who's going through the hard thing, like being the person who stands beside and walks with the person who is navigating what might be one of the hardest situations in their lives. Sorry, I'm advancing myself, but I'm not advancing this. There we go. Okay, so when we talk about risks and red flags, we can talk about them in lots of different ways. One is risks to clients. I think that's fairly straightforward. We're worried about status. Usually when we're at an immigration refugee law clinic, we're worried about, is this going to impact their legal rights? Is something here going to possibly result in them losing status or losing the opportunity for a pathway? This is really important for migrant workers specifically, is that many migrant workers, especially those we work with in Thunder Bay, have been recruited to Canada with a promise of permanent residence that might be realized after they spend a period of time working in Canada. Their work might be tied to a particular employer, but their promise of permanent residence, especially in our region, might also now be tied to a particular employer. Even if they have an open work permit, they might have a tied permanent residence opportunity. And so there are lots of risks around, are they going to be able to realize their goals? Are they going to be able to stay in status, stay authorized to work, keep money coming in so that they can support their families? A lot of the folks we work with have their whole family here or are supporting families abroad. Risk to self, risk to the workers. Workers would worry about liability. We often hear a lot of worries about liability. We have mechanisms in law that I won't get into a ton of detail about to deal with issues around liability and risks. And we talk about professionals, especially NGO workers included in that, acting within the scope of what a reasonable professional doing their work would do in that situation. And so just because something goes wrong, it doesn't necessarily mean that the professional has breached their standard of care, that they have done something wrong. So thinking about what is the standard for my profession. I know what it is for law. That's why Bianca was talking about, the lawyer reviewing everything. That's because when you're at a law office, the lawyer has to review everything. if you're at an office that's not a law office, the lawyer might not have to review everything, right? You would have to decide in your own particular offices, what is the standard that I need to adhere to as a professional in order to properly manage the risk? And that's just something we do every day. So the risk of liability, to my mind, is something that exists, but should not necessarily be a deterrent to doing the work. Because if you're working in accordance with the standard of care, which I know most professionals do all the time, then you should be safe. And then we can also talk about insurance and things like that people look into when they're doing any kind of professional work. And it's what makes me feel safe going forward and helping my clients to take the risks that they want to take. Because at the end of the day, making immigration applications is always a risk. And our job is to try to support people to take those risks safely. Risks to the organization are sort of similar, but also sometimes reputational, right? The organization does not want to hold itself out as offering something that in the end they don't end up being able to deliver on. They don't want to be seen in the community as not doing the quality of work that the community is asking of them. And so they may shy away from getting into an area that they don't have the resources to fully support, which is a decision each organization needs to make. And that's an organizational one that I won't speak to as much. I'm putting in here the risks to the movements and broader goals, because I think most of us in this room, if we work at an NGO, we're doing it as part of some kind of a movement, whether it's a migrant justice movement, a refugee rights movement, an access to justice movement. And the risk, I think, to movements sometimes in the context of this work is that if we accept the systems that IRCC or our government creates and we normalize them by doing work that sort of just perpetuates the complexity and the difficulty that these systems put people through, we risk sort of upholding systems that we would really like not to exist anymore. But I guess my response to that is to do the work and get to know it. It makes us really good, like CCR has been, at pointing out where things need to change. Okay. So when we're talking about the toolkit, we're still working on developing this idea of red flags. And I think that, and red flags, I would say, is just an area of highlighting high risk, maybe. When we're talking about it in the toolkit, we're looking at areas that respond to the concerns of the interview participants around when should I be engaging another regulated immigration professional, like an immigration consultant or a lawyer with expertise or practice experience in immigration law. I think that everybody's threshold is going to be different. It's going to be different on an individual level. It's going to be different on an organizational level. I don't pretend to know more about open work permits for vulnerable workers than an organization with 0 lawyers in it who does only open work permits for vulnerable workers. So your sense of red flags might vary organizationally, but areas of risk that we thought responded to the concerns that the participants had included things like the client's status or goals are in jeopardy. The client's safety is in jeopardy. That could be a situation of abuse from an employer, intimate partner violence, trafficking. And there are many organizations that deal with those issues and have significant expertise. It doesn't always mean referring out to a lawyer. It might mean bringing a lawyer in as part of the team if that's useful, and really making sure that that client is a priority. A client's problem engaging multiple legal systems can be very tricky because we might not want to miss a deadline in another legal system. And there are other rules around who can practice different types of law that get into law society stuff that we won't talk about here, but that's why that idea of multiple legal systems, it not just being an immigration problem, that ends up being one where you want to start talking to supports and engaging referral, perhaps. Other risks would be where frontline workers work with a particular client, risks violating their organizational policies, their ethical rules, or the standard of care that guides their work. One that comes to mind here that I think is sort of something we actually don't see very often, but is one that I think people worry about, and that's where a client has in the past or wants to in the future provide incorrect information to immigration. That gives rise to something that we heard in the interviews. It's called a misrepresentation. It's something that people were concerned about in the interviews. Also the idea around, like, what if we just make a mistake in an answer on the form? Will immigration consider that a misrepresentation that could make the person inadmissible to Canada and possibly give rise to consequences for the advisor? Those things are legitimate concerns. And we find that working through them with good communication and good question asking ends up resolving them, but it's a flag that we heard about. And then the last one, the frontline worker risks exposing the organization they work for to liability or reputational harm. Those would be red flags, hopefully not ones that come up very often. I was going to take you through scenarios, but I think I will save that. Yeah, I will save that for another time. I will conclude by suggesting a way of approaching these red flag issues beyond what I've already said. The idea of pausing once you see the red flag, pausing the work as much as possible, and then speaking with the worker who you're helping, getting more information. What might at first look like a document that's problematic or in an inconsistent piece of information from before might be very easily explained, and it doesn't necessarily have to constitute a red flag. Asking the client what they actually want to do. So sometimes a red flag might be, you don't seem to meet the eligibility requirement for the goal you're trying to achieve here. But the client might be okay with that goal not being their ultimate goal once they learn more about it. Sometimes a client might want to stay in Canada, but once they learn about what's involved in doing that, they might say, that's maybe not the thing that I want to do. But you might learn in conversation with the client that their goal is actually quite resolute. And so depending on what the client wants, your response to a perceived red flag might be very different. Communicate with others. So we have, and consent, of course, is always needed for communicating with others if you're going to share confidential information. But many of us are part of some kind of an immigration listserv. Put your hand up if you're part of an immigration listserv. I think I'm part of 4 or 5 of them. I have a separate email just for immigration listservs because I get so many emails every day. We are constantly in communication with each other because the system is so complex and because there are so many hidden rules. But chances are, if you reach out and ask, how would you handle this situation? There's somebody who's handled a very similar situation. And then you can share that information with your client and say, here's, think through some options and work through it. That person that you contact might be a regular or a regulated immigration consultant, or it might be a lawyer. It might be another experienced colleague who is not one of those regulated professions, and speaking with the client about who they want to be involved in their case is, of course, really important. Documenting. When it comes to risks, this is, I guess, I think this follows in every profession, but it's something that we make a huge priority out of as lawyers. Just constantly documenting in your own notes, and then sharing the plan by email with the client so that they have something to refer back to. So ideally, you've come up with that plan with the client, and then you've got something that you can come back to. If your client's not using email, most of ours are, but if your client's not using email, then some other format that they're comfortable with. And then following up if appropriate. So if you are continuing to work with that client, following up, making sure that they got everything that they needed. In true red flag, high risk situations, it's a project that you might be working on for some number of months. So another idea with this concept of red flags and risks and the challenges of working in this currently very difficult immigration environment. I'm hearing an echo of myself. A challenge is resources. Not every organization has the resources to step in where the state has sort of stepped out. Immigration services from IRCC are very difficult to access. We have to communicate through web form. If anybody's tried to phone them recently, good luck to you. I admire you and your optimism. But it's something we basically stopped trying to do. I remember when we first started the clinic and I asked the workers at the Multicultural Association, what did you used to do when you needed advice? And they said, oh, we used to call Marg, because Marg was the IRCC representative who was in Thunder Bay, but that office was shut down in 2015. And so there's not anybody that they can call for that sort of basic information about how a government program works. And so we've downloaded that onto NGOs.
Yeah, so I just wanted to give a bit of a context where we've come from and where I see us today. So rather than commenting directly on the toolkit. Jennifer talked a bit about how things might have been in the day. I'm old enough to remember when you did applications in paper and when applicants could actually go in and meet with an immigration officer and go through the forms with an immigration officer. At a certain point, the government decided that it would be more efficient for them and it would help them with the immigration processing times if they put the onus on the applicant to fill out all of the paperwork, to get together all of the documents, and to put in the application only when all of that was already complete. And then, of course, we've had the introduction of the digital platforms. Increasingly, year by year, there's more portals that are created and more applications that have to go via the portal. Often glitchy platforms which don't work completely as advertised and require a lot of patience and ingenuity to navigate. Often there are required questions that don't meet the realities of certain applicants. That's something we see a lot with refugees. For example, when you're asking for a work permit, you have to give your passport a validity date, which has to be in a future date. But as a refugee claimant, you don't have necessarily a valid passport with a future date. And so how do you validate it? Well, you have to know the workaround, which is not explained to you. So that's why you need to have some support for dealing with it. These are sort of more technical problems, but of course, there's a very basic thing that a lot of the applicants, the ones particularly that NGOs are working with, that may not have English or French, that may not know how to work with technology or may not have access to technology given their current circumstances. So there's been a tremendous transformation in what the immigration department expects of the applicants. And yet, throughout all of that, never any real consideration seriously given to how were applicants supposed to meet these new requirements that were being foisted on them. So that's where NGOs, increasingly over the past decades, have stepped in because they've seen a need, and that's what a good NGO does, serving its clients, it's serving its communities, it's identifying what their needs are and stepping in to assist them. But, you know, not a lot of direct funding, no thinking about how the funding was supposed to make that possible, left really very much to the NGOs to deal with. And then on top of all of this, the immigration department decided at a certain point in its wisdom to interpret Section 91 in a way that we considered to be wrong, and we consider to be wrong. And we asked Constance McIntosh to give us a legal opinion, and she confirmed what we thought, which was that their interpretation was wrong. It was wrong in law, but it was also wrong in terms of justice, in the sense that it was closing off an access to support for people without offering any solution, because the government never had any answers. I remember in a meeting with the immigration department saying, well, what are you going to do for a Yazidi woman who has been resettled to Canada? And she has her husband who had been detained and has now been appeared, and she can apply under the one-year window program for him to come. How is she, if the NGO is not going to help her, how is she supposed to make an application to bring her husband? She, of course, does not have funding to pay for a lawyer or even a consultant. And the immigration department had no answer to that question. So the effect of the government's reinterpretation was to make more vulnerable people who were already vulnerable. And it led to a lot of organizations, particularly the larger, better funded organizations, from taking the position that they were not going to offer these services anymore. And so what happened for some people in these organizations, the frontline staff were left in the impossible situation because they had their clients in front of them in a desperate situation. And many of them, felt like on principle that they needed to do what they could to assist people. It also had a lot of impacts on smaller and less well-funded organizations, ones that weren't generally funded by the government, but who worked more on a community basis of meeting the needs. And so they have found that they had many clients referred to them because they were the only game in town that was still offering those services. So within this context, the CCR decided that we would launch a program to look at quality of services. So that program has been referred to earlier today. It was a one-year project where we developed principles of quality of services, and it's great to see that those are being picked up in this toolkit that's being developed here. So yeah, we could see that there are ways that organizations can support their workers if they're willing to take this work on. But of course, it's very difficult to do that work in the context where the government is still telling many organizations that what you're doing is not legal. They never actually took action against anybody, but the threat of it was enough, and so many organizations weren't willing to make a change in their position or to offer these services, at least not formally. So it was great news when the government, and this was due to insistent over about a decade of advocacy from the CCR, and finally the Minister of Immigration agreed to correct their wrong interpretation of Section 91. And so that was something that, of course, we celebrated a great deal. However, the problem remained that they wouldn't say so publicly. So CCR asked them to make a public announcement, to put it on their website. They wouldn't do so. We had some questions. They developed this Q&A document, but they wouldn't put that on their website or send it out. It was given to the CCR for the CCR to promote. So that kind of made it a bit more difficult. And we heard earlier this morning that some people hadn't really heard this news, which is not that surprising in that context. Another problem that affects the usefulness of this change is the fact that funding remains unavailable. So certainly under IRCC, the Immigration Department, most organizations that have an agreement with them have a clause saying that they must not use their funding to offer these services. And then also just at the time that the reinterpretation was being made public, we saw increase in voices from legal practitioners and associations who were challenging whether NGOs are legally able to practice to do these sorts of things, because it could be considered practicing as a lawyer, which of course is illegal. So that added also to the concerns, which meant, many, especially the larger organizations, tend to be quite conservative. So conservative in their approach, and they're very risk averse. And you have somebody like Jennifer speaking about all the risks, and they're like, well, maybe, it'd be just easier for us to keep right out of this business. Boards who well, we're thinking of the interest of the organization. And so overall, there continues to be a large chill on the ability of NGOs to respond to these needs. And so I see, in a way, there's the kind of ghost of Section 91 problems still hanging over the sector. So there are these structural barriers which need to be overcome. And I want to end by perhaps suggesting switching around the whole perspective of risks, and to talk about the risks of not doing anything. Yes, you can do wrong things by helping somebody, but what are we doing when we don't offer assistance to people? And can we start from the point of view of saying there are a lot of people who have need of assistance? How do we collectively, not individually, not each one sector, but collectively, as government, as lawyers association, as NGOs, as everybody that is involved in making this success. And I want to pick up the point that Bianca made, and maybe smaller communities are better situated to do this, is, as she said, we have to work together. And that's what we need to do, is to work together so that collectively we have solutions that give vulnerable people the support that they need.
Thank you very much, Constance.
I can't believe I'm following Janet. I'm like, she's a force of nature. So I just have a few comments to share today. And, like Janet, when I looked at the toolkit, it took me back to, the bigger picture, which was that until 2015-ish, NGOs were offering services to their capacity, right? They were doing whatever they were capable of, competent to do, with very few limitations, right? They couldn't take an oath, they couldn't appear in federal court, but they were not in any way limited by anything but that which they were willing to learn up upon and do. And organizations like Janet's, of course, has been, fundamental for supporting the development of those skill sets. When we had that shift in 2015, which blocked paid staff from advising, right? It was absolutely crushing. It created instability. It created uncertainty. It was de-skilling of people working within NGOs, which is a terrifying thing to see. And some of Jane's research spoke to those very experiences persisting. So that 2024 IRCC clarification that they had been wrong all along was, extremely welcome, celebratory, and this toolkit is an important step to getting us back to asking the question which really matters, and which Janet, spoke to as well. And that question is, what are the capacities of specific NGOs to act? Right? What can they do? What do they want to do? What are they going to do when they cannot get an effective referral? Because we've heard a lot today about going, referrals, but there aren't always effective referrals. And that's part of why NGO scope does indeed end up expanding, right? So how can we support NGOs in those situations? I appreciated the red flagging that Jen took us to, in part because you framed it as something that the NGOs wanted, clarification on. And, if members of the community say they want information on something, I'm like, go, we've absolutely got to do that. But I do urge a sort of a shift in tone, away from a focus on things like, is Section 91 going to get us in trouble? Well, no, nobody is policing flowers, right? The real risks are more the ones that were raised here. And I don't think that NGOs are at all insensitive to those concerns, but I appreciate the systematic presentation of them. I would like to see, and the presentation did actually have this flow, but more of an expansion of a celebration of the green flags, right? Really, scoping was one of the things that Bianca spoke to. And I thought, like, what a wonderful exercise that is. Like, moving to be extremely express about what an organization feels it can do, and maybe put a little bit of a dream list forward about what else they feel they ought to do given their local client needs. And those are the sorts of things which other people, probably in this room, can support, the skill set that can get them there. Yeah, so I'm just going to close by saying that this toolkit is great. I'm really happy to see it's evolving. I'm very honored to be asked to help comment on its evolution. And part of what I'd like to see happen is this distillation into a very immediate tool of NGO empowerment and celebration. And I'm going to pass the mic to Dave. Oh, and one last comment is that, just because someone is a lawyer does not mean that they know anything more than someone working in an NGO. Like, if you were to ask me versus Janet a complex refugee question, go with her answer. So.
Thanks, Constance, and thanks, everybody. I know that I'm the last speaker before we open it up and then move on from there. So I'll try to be as brief as possible. I want to begin by congratulating the team that's producing the toolkit. I think it's shaping up to be very valuable guide for NGOs and their staff who support migrant workers. And this is an important project, and I expect the guide will become an essential resource. I do have some concerns similar to expressed by Constance and how I interpret Janet, about how some of the key terms that were addressed in Delphine's portion are being defined in relation to each other. I worry that there's a risk of reproducing a framework that inevitably chills the assistance that NGO staff might provide. But I know from what we've heard today and reading the guide that the team is alive to those concerns as well. So I really look forward to engaging with them on the development of that part of the guide. For my main comments, because getting that part right is very challenging, but I think also crucial. So that's a little concern I have, but I won't go into that any further. I'll just, for my main comments, I just want to return to my understanding, or my underlying belief that the toolkit is important and essential, and just explain a little bit why I believe that. So, as mentioned in the presentation, the toolkit is informed by research. Jane spoke to this. Field research that tried to gain an understanding of perspectives, concerns and needs of NGO staff, and also lawyers, paralegals and others that are providing assistance to migrant workers. And this produced a number of findings, one of which in particular caught my attention, which is that there are different perceptions on the role and impact of Section 91. On the one hand, all who provide law-related assistance to migrant workers, whether they're NGO staff or lawyers or paralegals or others, are motivated by the need to protect migrant workers. But on the other hand, in managing the ambiguities of Section 91, they prioritise different risks. And we've heard this mentioned a little bit already. As the toolkit says, lawyers focused on harm arising from unqualified assistance, while NGO workers focused on harm caused by delay, inaction, and lack of access to support. So given this, part of the aim of the toolkit, as I see it, is to provide a vehicle for acknowledging these differing perspectives, while also navigating them in a way that keeps the needs of migrant workers at the centre. It does this by recognising that there is an important role for all who are trying to help migrant workers with law-related issues. A role for lawyers, for paralegals, for immigration consultants, and for NGO staff. The toolkit provides a framework for integrating NGO staff into a constructive and collaborative approach that incorporates all of those who provide law-related assistance. Together, the combination of all of these roles and the collaborative assistance they end up providing can offer, I think, a broader ecosystem of legal support and access to justice for migrant workers. And in doing this, the toolkit's important and essential not only in the migrant worker sphere, but in many other areas of law-related assistance as well. And I just want to elaborate on that for one more minute. For a few years now, as some of you might know, I've been doing work on the important role played by community-based workers like staff at agencies serving migrant workers in providing assistance for law-related problems. I've been doing this work in partnership with Julie Matthews, who was formerly the Executive Director of Community Legal Education Ontario, and I've talked to a lot of people along the way, including folks like Janet and Constance and others. And Julie and I call this role community justice help and argue that it's both valid and valuable in many areas. Migrant worker support, refugee support, immigration support, but also housing support, support for survivors of intimate partner violence. We also argue that regulators and other stakeholders across the law and justice systems ought to treat community justice help as an essential component of providing and improving access to justice. In our view, regulators and other stakeholders have for too long tended to want to control and constrain community justice help. We argue they should instead focus on supporting and enabling it. But then the question arises as to, well, what does it look like to support and enable community justice help? Well, in my view, it looks like the toolkit. And it also looks like the similar work of CCR that Janet and others have referred to on defining high quality services. And so this is another reason why I think the toolkit is important and essential. It's a model that can be applied to support and enable community justice help across the spectrum of legal areas where access to justice is lacking for vulnerable and disadvantaged people, and NGO staff are at the front line, often the first place people go looking for help. So again, my congratulations to the team, and thanks.
Thank you so much. I think we'll move quickly to question and answer. We have a question online. I will take one online, then we'll take two in person.
Can you please give a concrete example of what permissible legal advice under Section 91 would be?
Do you want me to just say that Bianca's answering this? I actually tried to use an example and I didn't explicitly say it was an example. But regarding the open work permit for vulnerable workers, the part of assessing the abuse and being able to tell them, this is like, these are the documents that you need, this is like, gather the evidence, all of those things would be considered advice. And I feel comfortable enough to do that, but it doesn't mean that I don't have expertise in other areas. Like, I do understand the permanent residency pathways. I could give advice on that. Generally in our clinic, we don't. So I personally refuse to do it because our clinic doesn't do it, but it doesn't mean that I'm not capable of doing it or can't do it if I was working as like a settlement worker.
Thank you, Bianca. So we take two questions from the floor. Okay, that's the first question, and then I can work. It's okay. That's the first question. And then the second, yeah. Thank you.
Well, hello, my name is Eduardo Huesca. I work for the Occupational Health Clinics for Ontario Workers, and we have outreach workers on the ground working with migrant agriculture workers. So I just had a question, and it's kind of building on what Jennifer mentioned as the red flag and kind of working within the system, the immigration system, or trying to challenge it. But I just wanted to see if you envisioned a role for the toolkit related to challenging the tied work permit system that workers are under, and maybe just thinking about, flagging or helping organizations like ourselves flag cases where, for example, a non-extension is being used by employer as a form of reprisal. So we've had a case of 5 workers that all had their work permits not extended, and they felt that it was because they were the ones speaking about health and safety at their work. So just to I know that the toolkit is more situated around service provision, and I think that's amazing. We've seen something similar in taxes. So a lot of workers having folks help them with taxes, but in a way that actually was not great and led to people needing to then pay back money that wasn't good. So I'm all for this working with organizations like ourselves to provide information. But yeah, just wondering if maybe the toolkit has a role in helping organizations kind of flag cases that and maybe use language that then can go towards policy level challenging of the current system. Like maybe there's an ability to do both.
And you want to answer that?
I can answer it. I don't know that we have that built in right now, but I think it's something that would be really worth talking about in the afternoon around how we might be able to connect people up connect ourselves up as NGO workers, and then connect other people up with movements that are arguing for change and litigating change. And there's so much work being done that it would be, I think it's a part of our day-to-day work to do that work also. So if it couldn't be part of the toolkit, then I think it would be wonderful.
Interesting. And so that's how the toolkit has been expanding. And each time there are perspectives and stakeholders are bringing in different ideas, and it continues to expand. Thank you. So we have a question over here.
Thank you. My name is Iman Ahmed. My background is public health and international migration. I've got a couple of questions to you. First, congratulations on developing the tool and testing it. My first question is, when you look at it from a systems viewpoint, would you be able to say that the tool could introduce some uniform approach or streamlined approach to how organizations helping migrant workers would address the issues in question? And my second question is, again, from a systems viewpoint, what other benefits, in addition to the direct ones that are impacting the migrant workers, do you see any other benefits, such as time being saved? If you take a cross-section of the organizations, what other benefits do you see beyond the ones that are directly benefiting the migrants, but some that would impact the system and then come full circle to affect the migrants? Thank you.
Thank you. I'll quickly take the 2 questions and somebody else could add. And yes, your first question on
the uniform approach.
On uniform approach. Again, it's not supposed to be a Bible. It's a guide, and we believe that each organization will adapt it to its own use. But definitely, eventually, we're going to see a community of practice with the toolkit being a guide. People adapt it to their use, but then there are certain standards and parameters that run through everyday practice. And as with to your second question, I would say, eventually, yes, we believe that with the toolkit and engaging with it, cases wouldn't fall off the cracks. There wouldn't be inaction, there wouldn't be delays. So eventually, more migrants will have access to justice. And if there is less workload on the regulated advisors, then it opens up space for more people to seek and get professional legal help, which invariably gets more migrant workers into the justice system and be able to access justice. Thank you. I don't know if anybody wants to add something to it. Okay, question. Thank you.
Oh. So I'm coming at this from a couple different hats, but I supervise at a legal information clinic, and I really liked that we talked about referrals because it is very important. One of the things we have at our legal information clinic is we have a referral list, and we have it broken down by what the lawyer will do. So employment, housing, family, immigration, what type of immigration they can assist with, whether they accept legal aid, whether they have whether they will take pro bono, what their rates are. We have all that information, and I was wondering if your toolkit provides organizations perhaps like a template where they could build their own referral list, immigration consultants, because it's true. One of the biggest things we can do for people is point them towards somebody credible who's affordable, right? And so that's been a huge thing. And then also being the link between them and the lawyer, right? And the other way we do the link, and I don't know if your toolkit addresses this, is that there is a role to sit down and say, look, I can't give you advice. You're going to go see a lawyer about this, but I'm going to prime you on what the lawyer is going to be talking to you about, right? Because often lawyers don't have the time to sit and explain and get, that's what that procedure is. That's where you'll find more information. I often liken it to, when you receive a serious health diagnosis, you walked into the doctor's office. I don't have a lot of medical knowledge. The doctor talks at you and you're like, oh, okay. And then, nobody's there to sit down and say, well, this test means that, and this treatment's that. So I think there's also a role, I don't know if your toolkit addresses that, but frontline workers, they can also help in that way so that the person walks into the office knowing what the lawyer's about to ask for and everything.
Thank you. Thank you. That's a very interesting perspective. We haven't considered that part. We just said provide any kind of support that you can, but we didn't go into the nitty-gritty of, okay, this is what it should be, and all of those kind of things. But then talking about structuring the partnership, we recommended some key resources and referrals, how to develop your referral list and all of that. That is part of the list. Thank you.
So where do human rights commissions fit within the network/ecosystem? As a coordinator at an HRC, I often refer people out to seek legal advice, but the number of migrants reaching out to HRC are increasing exponentially.
I mean, I think it's a symptom of the laws that migrants are dealing with and the structures that they have to work within and the employment relationships that they have, that they're reaching out more to HRCs or human rights commissions. It's interesting at our clinic. I could go into the details of what our insurance allows us to do. We're not insured currently to provide human rights advice. And if we did, we would be exceeding our capacity in terms of what our one lawyer can do. And so when our clients come with human rights needs, we would refer them to a human rights commission. So you can see that even the referral pathways are not great. In Thunder Bay, we don't have a human rights lawyer on the ground. And the market around legal services and what kind of work people take on for pay is a whole other topic of conversation around what services exist where and why and that sort of thing. So I think depending on the situation, it just depends on who you have locally, who you know provincially. We have certainly been able to reach out to specialty clinics like the Income Support Advocacy Center to take on cases where we're dealing with employment rights and discrimination. And our local community legal clinic can sometimes help, but then there are income requirements. So you can see it can get very complicated. And ideally, people just wouldn't have to make human rights complaints because their human rights would be respected. So I do come back to that sometimes, while acknowledging that that's a perfect world and not a reality right now.
I just wanted to briefly add on Anna's question quickly on the contact list, and then I will give you the floor. We had lots of backs and forth between Jen and myself because I was opposed at first to having a contact list in the toolkit. Remember that we did this research first in Ontario. So the idea would be to, of course, expand it to other provinces if possible. But you see, I'm a bit torn apart on contact list because we spend a lot of time doing them. And then sometimes they are not updated. So and that's a problem, because if you use a contact list that is completely outdated. So if you have ideas as to how make sure that the contact list is, always alive and always useful, and because we know that most of the time it's also personal connections, right? And this is what I find difficult. So on the one hand, of course we need that because this is the key to refer. On the other one, when people leave, sometimes their own connections live with them. And so I'm just wondering how to find the right balance between the two. Janet?
His hands were up. So we take Scott and then we take Janet, please.
It wasn't a question. I was just going to follow up.
Jane, I had the mic. Sorry. Good morning. Oh, I think it's afternoon now. Good afternoon, everyone. And thanks to everyone who had contributed to the conversation, and also thanks to Jane and her supervisors, as well as the team who did this beautiful research. So I have two questions actually, and okay, just one.
Just 1 minute.
Just 1 minute.
We were not done with this question. She was going to provide another answer before you ask.
Please. Do you want me to wait?
Yes, please. Can you give us?
Yeah, I don't need to interrupt.
Please, can we finish up? Then we.
I was just going to suggest that, does this work?
No, you need to put the mic. Sorry, Janet.
Hello?
No? Yeah. I was just going to suggest that rather than having an actual contact list, more is something to suggest that that's one of the things that each organization should do, is to develop the list that is appropriate for them in their area of work and their community. And that maybe it's something that they should attempt to do collectively too, because in some communities, there are several organizations working somewhat in the same area, and it would be good to pool resources and to, see how, as part of the kind of working together, the community can put that together.
Yeah. Thank you. So,
okay. So my name is Eukaria, and I'm a fourth-year doctoral student with the Institute of Feminist and Gender Studies, with my research focused on improving the quality of refugee education in Africa. I was drawn to this public lecture, given its intersection with my field of study as well as my research area. And in the course of my scholarly journey, one thing I'd like to do is always push out or ask questions wherever I need clarifications. And based on the fact that I do not have a legal background, like I mentioned earlier, there's a certain word that was used, I think, by Dr. Ezirigwe as well as her supervisor, and it's consideration in most of your presentation. And I'm wondering, like, we use this word in English all the time, but legally speaking, what does it really mean? I'd like to know. And then I think that the discussion about my second comment is already on the go, but I was quite curious, given the fact that I work with NGOs. I wanted to know, because this is a beautiful research, and what is the plan for dissemination? Because when Jane started her presentation, one of the problem statements she raised was the fact that a lot of organizations didn't even know about the clarification. So I took that and I'm like, okay, now this is a very significant problem. And now you have brought a wonderful solution, which I really applaud. And I'm wondering, what is the plan to make sure that these same organizations get to know about this beautiful toolkit that you have in place now and adopt it as well?
Very, very briefly on that. It's complicated, but the the legal terms is just one part of the toolkit. So we were wondering really how to present it. But of course, we don't leave you with the legal terms only, because what is the purpose of a toolkit? But at the same time, we felt that it was necessary to go through those legal terms, because the legal terms are also the terms that make it complicated. So we are fighting and it's not the end, but just to reassure you, we felt the need to explain the legal terms, and we recognize that there is room. I'm looking at David because you said you were not sure. That's quite the good way to do it. We will work on that. We will make sure that we have a nice way of presenting it. But at the same time, we didn't want to just guide people without providing, right, what are the legal implications behind the words and, the legal significance. So it's, we feel it's important to have a section on legal terms, but we also, of course, are not limiting ourselves to the legal term. I think and so I agree that the presentation was not the best example, but at the same time, we really wanted to provide you with a snapshot of what the toolkit looks like. But totally agreed, we cannot limit ourselves to the legal terms, but we feel we need to go through them and make them as clear as possible, which is, I know, quite difficult currently.
Thank you. And just the second part of your question on dissemination, like I said, we intend to also get into consultations, especially, and we're interested in this building of partnerships between organizations, because invariably, I think that's the only thing that is going to move the work forward. There has to be some kind of an institutionalized way of having the partnerships so that everybody is on the same page and working together. Scott? Yes.
Hello, thank you. Scott Florence from the Sudbury Workers Education and Advocacy Center. We serve Sudbury, the District of Sudbury, and Northeastern Ontario in general. I really want to say thank you to Jennifer for sort of raising the thing that we didn't talk a lot about, but this is a systemic issue, right? Like, these are problems caused by our IRCC. That is the biggest trouble to our clients. And so I did find it amusing, not only Jennifer, but a couple of other people sort of said, red flag for your client is if their goals and their status is in jeopardy. So everybody that came to Canada looking for PR then, right? Like that describes everybody under the modern regime, right? I don't want to beat the referrals to any further, but there's nobody in Sudbury that I can make a referral to. Most of my clients won't qualify for legal aid. JusticeNet.ca reaches nothing in our area. Cold calls to Toronto or Ottawa are not returned. I do have a couple of people that I've made that personal connection I can refer to, but they may or may not be taking on clients at that time. They may or may not get back in a timely fashion. If referrals were an option, we wouldn't be discussing whether or not NGOs can be helping and how we can be helping. So I think that's also really important to go to. It's not the question I wanted to ask. What I really wanted to ask actually was, who's policing this consideration, and how much should a small NGO actually be worried about it? Because frankly, I am going to accept that plate of cookies when it's brought in. I love me some cookies, but I'm more worried about things like, well, what if I do want to do a partnership with another organization in my region in exchange for non-financial items, the way that nonprofits often do, partnerships with. So who's actually policing this, and how much as a small NGO do I need to be worried about it?
I think this is a question that we need to think more about, and that maybe we need to ask IRCC more about. Yeah, I'm with you. Our clients give us gifts all the time, and it would be rude to refuse them. And I think also there are some big challenges there that need talking through.
I think at the end, our goal is also to have some good discussion with policy people, and we need more funding to train people. We need some resources to make sure that we can make it work in a good way. Something that has been asked for a long time, but I think it's key. It's absolutely key. Otherwise, it won't work as it is expected to. totally. That's the plan also, to make it move to the next step. Because relying on good people's good faith and people pro bono time and volunteer time on all parts doesn't work in a context where everyone has been so stretched already. Absolutely, yeah. So that's a call for that as well, hopefully, and
I'm mindful of the time, and is there a question online? Okay, maybe we'll take the last question from online so that we could.
What is the timeline for dissemination of the toolkit?
Again, just maybe following or just reiterating what Delphine has said. It all depends on what resources and funds are available, because these things are, so we don't have a set timeline, and we have internal set deadlines, but we can move forward on those if there are no support and funding.
But we will make it available for sure.
Definitely.
Yeah. So we cannot promise on anything, but please stay in touch with us. The idea is really to gather the feedback from as many people as possible to make something that is good, to test it as well. We want to test it. And of course, at the same time, do some advocacy work for, funding opportunities, start something bigger. But we will make it available, of course. We just feel the need to integrate our experts' feedback, to test it before it goes out, and then after that it will be yours. I think that's the objective.
Thank you, everyone. I think I'll take the last shot on this. Yes. So I have the privilege of thanking everyone. I want to start by thanking the attendees, both those that are online and then in person. Thank you so much for coming and hearing us out and making your suggestions and pointing out the blind spots. There is no perfect research, and I think things are better when we work together, and we've taken your feedback, but we don't want the discussions to stop here. Please reach out to us if you have suggestions, especially on how to build this partnership so that we can all work together. That will be very interesting. I want to, and I've thanked all the institutions, but I want to take our time to thank the research team for such a wonderful job so far. Delphine, Jane, Bianca, and some other anonymous ones. We're very grateful that we've been working together. We've had some tensions working on it. There have been disagreements and all of that as to, and rightly so, as to interpretations given and all of that, but we've been able to agree on certain things and moved on. Again, I want to thank our interviewees who are our co-creators in this project. A lot of the insights, the components of the toolkits, what it contains, the case scenarios that we're building all came from them. And a lot of them are online. I want to thank you so much for volunteering your time and contributing to this research. Again, I want to thank the expert reviewers who have taken their time to engage with this toolkit. We're very grateful that you've brought out your time to, give us some feedback. So many of them have been such eye-openers. We're like, oh, wow, yeah, that's the way to go. And on a personal note, I want to thank my family because they've had to put up with certain things and actually some demands
from my time while I'm doing this work. And so at some point, my 4-year-old will be like, "Mommy, are you doing Delphine's work?" When he feels I'm very, glued to my, like, "Mommy, are you doing Delphine's work?" I'll say, "Yes, I'm doing Delphine's work." "Okay, fine." And then he goes away. So it's taking a lot of time from my family, but I'm happy that with Delphine's supervision and support, this work was able to be done. I thank my parents and siblings for all the support. And I thank you all for staying with us till this time. Please, we'll do a group photo. Oh, yes. Yes, I forgot some very important people that made this event happen. So the event organization team. Renata, the chair coordinator, she's been on this for months. You won't even, yes, please. Yes. And then we have a few volunteers, Christy, Oyime, Kambili, Lee, and Jennifer. They've all been working together to make this happen. Thank you to Veronique. Veronique has been amazing. And like, I went to see her in the room now, and she has a bruise on her knee. She fell while still trying to support this project. And she's been with us for the past 2 weeks trying to, get this together. And she was here by 7-ish, trying to make sure that
We were actually talking about
how narrow the staircase is where. Yeah, so please, a warm round of applause to Veronique. And yes, she's feeling much better, and I hope she gets well soon. Yes, photographer, thank you so much for capturing those candid moments. Yes.